Good afternoon, everyone. Thank you for joining us. It is 12 o'clock. We're going to go ahead and get started with our presentation. Welcome to course number 3967, Business Unusual, a practical overview of bankruptcy in Florida amidst COVID-19. Today's presentation is brought to you by the Business Law section of the Florida Bar. This presentation will be part of our COVID series that began on April 30th and continues to grow. The live presentations of the CLEs in this series will be free to all registrants, and we encourage you to sign up for any of our upcoming events. All presentations in this series are also available for aftermarket viewing at no cost on our section website. Information on each of the upcoming COVID series CLEs is also available on the Business Law section website. We also invite you to visit our website's COVID-19 page that we continue to update with the most recent information. Lastly, we invite you to become a member of the Business Law section. Information on how to become a member is on our main page of our section website. If you have any questions about CLEs or how to become a member of our section, please do not hesitate to reach out to me. All of my information is on our section website. So this presentation is 1 hour, and we ask that all questions be sent via the question and answer box that can be found at the bottom of your screen. The presentation will be moderated by Jody Dubose. And now, Jody, I'd like to go ahead and turn that over to you.
Stephanie. Morning, everyone. For those of you who are in the Central Time Zone, it's still morning up here. For those of you who are in the Eastern Time Zone, good afternoon, and thank you for joining us today. As Stephanie said, my name is Jody Dubose. I am an attorney with Stichter, Rydell, Blaine, and Postler in the firm's Pensacola office. I am a past chair of the Bankruptcy UCC Committee of the Florida Bar's Business Law section, and I'm also a Subchapter 5 trustee in the Northern District. The distinguished speakers that I have joined me today for the presentation include the Honorable Mindy A. Mora. Judge Mora is a bankruptcy judge in the Southern District of Florida, sitting in the West Palm Division. She has been seated there since April of 2018. Prior to her appointment to the bench, she was a partner with Bilzen, Sumberg, Baina, Price, and Axelrod LLP. She is a former chair of the Business Law section and is also a fellow with the American College of Bankruptcy. We also have Mr. Doug Niway. Mr. Niway is a standing Chapter 13 trustee in the Jacksonville Division of the Middle District. He has been there since October of 2007, and prior to serving as trustee, he represented consumer debtors as managing partner of Bond, Bodis, and Niway, PC. We also have Mr. Charlie Postler. Mr. Postler is a partner at Stichter, Rydell, Blaine, and Postler in their Tampa office. He was named Tampa's Lawyer of the Year in Bankruptcy and Creditor-Debtor Rights, Insolvency, and Reorganization Law for 2020 by U.S. News & World Report. Mr. Postler is consistently named a Florida Super Lawyer and is also rated AV by Martindale-Hubbell. Last but certainly not least, we have Mr. Guy Van Balen. Mr. Van Balen is an Assistant United States Trustee in the Middle District. He is assigned to Tampa and is also the acting trustee in the Miami office. He has held that post since August of 2019, has been with the United States Trustee Program since 1989, and immediately prior to moving to Florida, he served as the Assistant United States Trustee in the Utica, New York office for approximately 23 years. As Stephanie mentioned, today's topic is business unusual, and it is unusual indeed. Bankruptcy in Florida has changed quite a bit over the last few months. Just to set the stage for today's presentation, I wanted to mention a few recent statistics for what the courts and the system are facing right now. AP reported just this morning that 2.4 million workers are seeking unemployment at this point in the United States, and total layoffs have reached nearly 39 million. The unemployment rate was 14.7% last month in April 2020, and it is expected to climb. In Florida, our unemployment rate hasn't surged quite that high yet. We were at 4.3% in April, but it is expected to surge as high as 20% in the coming months. As you've no doubt seen on the news, Florida unemployment benefits are limited and the program continues to be plagued by technical issues brought on by the new virtual age we're living in. Florida stay-at-home orders and travel bans are beginning to lift, and businesses are slowly reopening, but uncertainty as to whether reopening will continue if infection numbers start to rise again. For businesses that are allowed to reopen, there are increased operating expenses from social distancing and sanitation requirements. There are also a host of workforce issues, including employees having to mandatorily quarantine, loss of employees due to furlough or termination during the shutdown, and then personal limitations that we're all facing as humans, like a lack of childcare and high-risk classes who don't feel that it's safe to interact with the public. CNBC predicts that there's a 70% chance of a recession in the next 6 months in the United States. So it is not surprising that these figures have resulted in a dramatic increase in bankruptcy filings being estimated in the coming months. Existing debtors are also experiencing significant complications, as you will hear about shortly. And with that, I'd like to jump straight into the meat of this because we're hoping that we can keep this to an hour. There's a lot of material to cover. And I would like to turn it over to Charlie Postler, who is going to tell us about the legislative intervention on a state and federal level.
Sorry about that. Good afternoon, everyone. This is Charlie. Good afternoon, everyone. This is Charlie. We have a lot to cover, so I'm going to be moving through my materials fairly quickly. One of the things I want to let everybody know is that whatever I'm saying during this session, in some cases, a lot of this information is changing daily, sometimes hourly, but we're going to try to give you the most up-to-date information that we have on all these topics. My topics are going to primarily deal with the CARES Act provisions dealing with the Paycheck Protection Program and how that affects Chapter 11 debtors, which will be the bulk of my presentation. And I'll touch on some Subchapter 5 amendments in the CARES Act, as well as tax benefits to corporate debtors. We'll go briefly through the eviction and foreclosure status in the state of Florida on a federal level, and then we'll also talk about current unemployment issues in the state of Florida. The first topic we're going to talk about is the issue that's circulating around the country right now in a lot of jurisdictions, which is primarily why Chapter 11 debtors are not being provided access to funds available under the Paycheck Protection Program. So, as everybody probably knows, as part of the CARES Act, there have been two tranches of funds made available to borrowers. The first is for Jody. Will you put my slides up? I'm sorry. So the first tranche of it was $349 million, and the second one was $310 million. And so the first tranche ran out very, very quickly because a lot of people were using those funds and companies that probably were not entitled to those. And so the concept is that the PPP is essentially a loan program that's been instituted to be administered by the Small Business Administration, and also to be the loans to come from SBA lenders, traditional SBA lenders. And so there are no underwriting requirements for the loans. There's no guarantees. There's no collateral required at all. But eligible companies can borrow up to $10 million to be payable 2 years after the initial funding of the loan at a 1% interest rate, and so forth. Okay, here we go. That's Jody. That's Judge Morris. We can put the other one up. I appreciate it. So the proceeds of the loans are supposed to be used primarily to pay employee payroll items, and also for rent, utilities, and mortgage debt. So the whole concept of this is that borrowers are entitled. Next, go 2 slides in, Jody. The whole concept of this is that borrowers are entitled to use this money and then have it forgiven at a later date. So the forgiveness part of this process, the application to have the loans forgiven was just put up on the SBA website last Friday, I believe. And the concept is that any funds that you obtain that are used for the certain purposes based on percentage limits will be available to be forgiven at the end of the term, which is June 30, 2020. But it's basically on the 8 weeks following the initial funding of the loan. So there has been a lot of commentary in this, and everybody looking at this quote as sort of like free money, so to speak, because the intent of this is that people would be able to use this money, keep people employed, and then they would come back and file for forgiveness. And then even if they couldn't get forgiveness, they were going to be able to get a loan at 1% interest rate. Next slide, Jody. So the question is, can a debtor in possession obtain a PPP loan? So on the application form that everybody's required to fill out, there's a question number 1, that says that you have to certify that the applicant or the owner of the applicant is presently not involved in a bankruptcy. And if you answer yes, then the loan will not be approved. So when this program came out, and I think the initial funding date when the program was open was April 3rd, the SBA had really provided no guidance on this question whatsoever. So it led to a lot of confusion among borrowers and the SBA lenders. And even the loan documents that were received by these borrowers required them to certify as to the prior certifications, and the penalty for failure to properly certify the information includes fines, imprisonment, et cetera, et cetera. So there was a lot of uncertainty when this thing first started out, and so in a lot of pending Chapter 11 cases, the debtors were going to the SBA lenders and saying, yes, I filed bankruptcy, but I would like to get the money. And what was happening is the lenders were confused, everybody was confused, and so nobody really knew what was going on. And then on April 24th, next slide, Jody, the SBA issued its 4th interim final rule, which again is the 4th rule now. This is 3 weeks after the program essentially got started. And this is basically the rule that where the SBA takes the position that you cannot be an applicant in bankruptcy, or at the time you submit the application, or if you submit the application and then you file Chapter 11 before the loan is dispersed, and in that situation also, you're not entitled to get funding under the Paycheck Protection Program. And the timing on this is that by statute is the lender must fund the loan within 10 days of approving the applications. And a lot of these applications are being routinely approved by the banks because there's very little information you have to provide except for your payroll numbers, and then you do a calculation based on that. So what's happened is there's been a lot of litigation that has erupted sort of since mid-April and even up through, this week, regarding whether or not a Chapter 11 debtor has the entitlement to these funds. And the SBA has taken the position that no, you don't, and so forth. And the procedural posture for all these is that TROs are being sought by debtors in Chapter 11 cases. And the SBA is now sort of geared up. They weren't initially geared up like they are now, but they're geared up and they're filing responses, and these things are being heard by bankruptcy judges all over the country. So Judge Mora is going to jump in at this point and kind of tell us what's going on out there and what's happening in a lot of these Chapter 11 cases, and what are the key issues that judges are looking at in making their rulings. And Jody, if you would put up Judge Mora's PowerPoint, that would be great.
Thank you, Charlie. While Jody is making those technological arrangements, I want to thank everyone for attending this morning. There has been throughout the country a lot of challenges to the SBA's administration of the PPP program, mostly in the bankruptcy courts through the SBA's position that debtors are not permitted to seek any of the funding available under the CARES Act under the PPP program. There have been to date about 23, at least that was through last Friday, and there could have been even more filed since then, 23 cases where this issue has arisen. The debtors, starting with a debtor in the Southern District of Texas, Hidalgo County Emergency Medical System, have been taking a similar tack in terms of what it is they're seeking to do, and the SBA has been responding fairly consistently in all those cases. So Jody, if we go to the next slide, please. The first issue that's being raised, this litigation is brought as an adversary proceeding, and then emergency motions are getting filed for entry of a temporary restraining order, and setting up a hearing schedule and setting a preliminary injunction. And the issue that's being raised is whether the debtor is eligible to get funding under the Paycheck Protection Program that Charlie has just described. First of all, there is nothing that the debtors tell us judges who have gotten these types of actions filed, nothing in the CARES Act that expressly states a debtor cannot obtain funding under the Paycheck Protection Program. And yet the SBA has created an application form that requires the applicant to disclose whether it or an owner of the applicant is a debtor in a bankruptcy case. If the applicant answers this question in the affirmative, they say yes, check off the box, then that will result in the SBA rejecting the application for PPP funding. And the debtors are therefore seeking injunctive relief in order to prevent the SBA from asking what we refer to as that bankruptcy eligibility question. Okay, next slide, Jody. So the legal arguments that are being made start with the question of does the bankruptcy court have the authority to issue an injunction against the SBA? And the SBA claims sovereign immunity under the Small Business Act. Section 634B1 says you can't sue and you can't get injunctive relief against the administrator of the SBA or the SBA. And the debtors come back and respond and say, no, that's not exactly true. We have rights under the bankruptcy code. First of all, we've got essentially the all writs power under section 105. In addition, under section 106, it expressly says that sovereign immunity is waived when you're dealing with certain sections of the bankruptcy code. And among those sections is section 525 that prohibits discrimination against bankruptcy debtors in connection with certain kinds of grants by a governmental entity. And so the debtors assert that they have the power under sections 105, 106, and 525 to enjoin the SBA from imposing the bankruptcy exclusion when applying for PPP funding. This issue of whether or not the debtors can use injunctive relief against the SBA depends upon an interpretation of sovereign immunity. And one of the courts up in the First Circuit that was considering this issue looked at a case called Ulstein Maritime Limited versus US. It was decided by the First Circuit. And basically what they said is where an agency is exceeding its statutory authority, and injunctive relief won't interfere with an agency's internal operations, then a federal court has the power to issue injunctive relief to prevent the agency from acting beyond its statutory authority. All right, next slide, please, Jody. And so the debtors are making an argument about discrimination under the Bankruptcy Code, looking at section 525. And they argue that the Paycheck Protection Program is really not a loan program. Really, it is a grant program. Because if you, as a applicant, get this funding and you use it properly, 75% for payroll over the 8 weeks after you get funded, and no more than 25% for other permitted expenses like mortgage interest, lease payments, utilities, then the loan will get forgiven. And so the debtors say, no, this is a grant program, not a loan program, and therefore it falls within section 525. And because of that, the SBA's bankruptcy question is improper as it discriminates against bankruptcy debtors. The response that the SBA is making is that you're interpreting section 525 improperly. That only applies to a license, a permit, a charter, a franchise, or other similar grant. And therefore, you can't interpret the Paycheck Protection Program to be like a license, permit, charter, franchise it's really a loan. It's called a loan in the statute. It's not called a grant. And therefore, because it's not like a license, permit, charter, or franchise, and it's really a loan, you shouldn't be able to rely on the bankruptcy code and section 525. And then the SBA says, you know, even if it's a grant, look, it's not like these other things that are listed in 525. So the bankruptcy court really doesn't have the authority to rely on that section in order to get injunctive relief against the SBA. Next slide, Jody. So the issue on section 525 really has broken down between different circuits because of prior circuit precedent. The Fifth Circuit, and I believe also the 10th Circuit, construes section 525 narrowly. They say a loan is not a grant. And in the Fifth Circuit, the case that they've been relying on is Exquisito Services, Inc. versus USA, case from 1987. In the Second Circuit, there is circuit precedent that construes section 525 more broadly. It has looked to see other types of instances where section 525 has been utilized to prevent an act by a governmental unit that was seeking to exclude bankruptcy debtors. And based on that precedent, which is Stoltz versus Brattleboro Housing Authority, the courts in the Second Circuit that have looked at this issue have said funding that is forgiven if it's used properly is a grant, and therefore we're going to say section 525 applies. Next slide, Jody. So the question is whether or not the SBA has exceeded statutory authority by excluding debtors or debtor-owner applicants from eligibility under the PPP. And the CARES Act, as Charlie has said, has very limited eligibility requirements for PPP funding. The applicant had to be in operation on February 15, 2020. It had to have 500 or less employees. It had to be paying salary and payroll taxes or independent contractors. And it has to be able to certify that it's going to use these PPP funds to retain its workers or to make mortgage payments, lease payments, and utility payments. That's what the CARES Act says in terms of eligibility for funding. There's no mention of the applicant or its owner being in bankruptcy. There is no personal guarantee required, and there is no collateral required being put up by the applicant. All right, Jody, next slide. And so the next critical question is, well, if the CARES Act is silent on the issue in the PPP program, was adding the bankruptcy exclusion to the PPP eligibility an arbitrary and capricious act by the SBA? And so the debtors argue, look, Congress knew how to make being in bankruptcy a requirement for a loan, or not being in bankruptcy a requirement for a loan. In fact, there is another section of the CARES Act, section 4003, that expressly prohibits loans to medium-sized companies, which are defined as 500 to 10,000 employees, if they've been in bankruptcy. That particular loan program expressly has that as an eligibility requirement. So because the debtors say the PPP doesn't include that as an eligibility factor, the SBA must be deemed to be acting in an arbitrary and capricious manner by inserting this additional no bankruptcy requirement for eligibility under the Paycheck Protection Program. Next slide, Jody. And so the SBA's response is, look, this was a loan program under Section 7A of the Small Business Act. All the loans under Section 7A were required as a federal agency to determine that those loans are of such sound value or so secured reasonably to assure repayment. And the provision of the CARES Act that deals with PPP loans are supposed to be made under the same terms, conditions, and processes as other Section 7A loans, except as otherwise provided in this paragraph. The CARES Act also gives the SBA express authority to develop rules and promulgate rules regarding implementation of the Paycheck Protection Program. And as a result of that, the SBA is determined that making loans to debtors would present an unacceptably high risk of unauthorized use of funds or non-repayment of unforgiven loans. All right, Jody, next slide. And so the question then is whether or not the courts are supposed to employ the Chevron deference question. All the courts that have looked at this issue recite this particular standard. Well, what is that? Well, under Chevron USA versus National Resources Defense Council, a 1984 decision of the United States Supreme Court, the court is supposed to look at whether the statute is ambiguous. If the statute is unambiguous, then the reviewing court must give effect to Congress's statements, irrespective of any contrary agency interpretation. And so the applicants argue, as I said before, that there's only two criteria for PPP funding: that they were in business in February 15, 2020, and that they've got less than 500 employees. And then I'm not even going to try to say this Latin phrase because I'm sure I'll mess it up, but the English translation of it, the expression of one thing is the exclusion of the others. Because we've said this is the eligibility requirements, there can't be any others. And the SBA, the debtors argue, is making this up. And that was the analysis of a district court up in Michigan, not in a bankruptcy scenario. It was in the DB Diamond Club of Flint versus US SBA case that was recently decided, I think, last week, where the district court was dealing with the question of whether a sex club was eligible for getting funding under the PPP, and ultimately determined that it was appropriate to enter a TRO and preliminary injunction against the SBA from excluding the sex club, although historically the SBA has not allowed SBA loans to be used for borrowers who appeal to prurient interest. So it wasn't a bankruptcy case, but very instructive on eligibility for the PPP program as determined by this district court. Now, the SBA argues that its interpretation of the CARES Act is reasonable, so the statute must be ambiguous, and therefore, under the Chevron deference question test, the agency's interpretation must be referred to. The agency is the one who's supposed to administer this program, and the agency therefore can exclude debtors because that is historically how they have determined whether SBA funding should be extended. All right, next slide, please. All right, so with that, I'm going to turn back to Charlie so that he can now talk further about other questions that have come up with the PPP program. Charlie?
Thank you, Judge Moore. That was excellent. Okay, great. Back on. Thank you, Judge Moore. That was excellent. Jody, can you go back one page, please, on the slide? So the question is, just so you know, the SBA, now that they've sort of got their act together, I think, is filing responses to these TROs, and they're attaching, hundreds of pages of decisions, which are obviously in their favor. So that information is available. I don't know if it's on the ABI website yet. I know a lot of these decisions that have been posted that, there's probably like Judge Moore said, 20, 25 decisions out there. So, it's evolving every day. My view is the decisions are sort of 50-50 right now, but again, some of the earlier decisions were when the SBA had not published that fourth interim final rule. So, but the information is available for people. So, question is, what are some of the workarounds? So, what I've seen, and I haven't followed this all the way through, is that there apparently is no prohibition to borrowing the money, securing it, getting the funding, and then file Chapter 11 after you get the PPP loan advance from the SBA lender. And secondly, what I've also seen in a number of cases is that the courts are allowing debtors to dismiss their Chapter 11 cases and entering orders allowing that, and then the debtors then can go file their application and get the PPP loan, And then based on the particular judge's order, they can refile the Chapter 11 at a later date and so forth. So it just kind of shows you how ludicrous the situation is, that you can actually get the money, file Chapter 11, that's fine, but you can't file right in advance of that. So, so next question is, are any of these subject to existing government debts and collection efforts? And so far, what I've seen is that, and I think we have a question that somebody had put up on the site, but so far what I've seen is that banks are very, very hesitant, as well as governmental agencies, try to set off these funds. And in situations where that's happened, you know, those have been reversed. So I think it would be really bad you know, publicity for a bank or a governmental agency to try to do this. But of course, you know, it may happen, and I know it's trying to be corrected. I haven't actually been involved in any of those situations, but I'm sure it's happening out there. Next slide, Jody. So everybody knows about the stimulus payments or recovery rebates, which have been paid out to, you know, tens of millions of people so far. And so there's a bankruptcy question. Two bankruptcy questions that have come about is, should this be included in the calculation of current monthly income or projected disposable income? And secondly, are those funds property of the bankruptcy estate? So the CARES Act states that the rebates are excluded from the statutory definitions of current monthly income and disposable income for purposes of your Chapter 7 and Chapter 13 cases. And the U.S. Trustee's Office on question 2 has issued a notice dated April 7, 2020, which is available, which essentially says that, you know, it's highly unlikely that the trustee is going to go seek to administer that payment based on a number of circumstances, including the amount of the funds available, the use of those funds, the necessity of those funds, and so forth. So I think every trustee out there that seeks to go after those funds has to go to the U.S. trustee first and get their approval before they do anything on that. But I think everybody's saying, you know, we're not going to let that happen right now. So, and that notice is available for anybody that wants to see. It's a one-page notice. Jody, will you go on to the next set of slides for the subchapter 5, please? So the next topic I have, which will be very, very brief, is going to be discussed a little bit by the panel. And we do have a set of slides. I'm not going to go through most of the slides, but they will be available after the seminar for everybody, is to talk about the Reorganization Act of 2019, or the Small Business Reorganization Act, also known as Subchapter 5. This act was enacted on August 23, 2019. It's effective with respect to cases filed on or after February 19, 2020, and is codified in 11 U.S.C. sections 1181 through 1195. It was also amended as part of the CARES Act, which I'll get to in a second as to what the amendments were. So now we have, Judd, you can go to the second page of the slide. So now we have 3 types of Chapter 11 cases. We have a regular Chapter 11 case that we call a standard case, a Subchapter 5 case, and then still a small business non-Subchapter 5 case. Judd, you can flip the page. Next slide, please. Thank you. So the debtors must elect to proceed. Go back one page, please. The debtors must elect to proceed under Chapter 5. If they do not make the election, then they're going to be stuck in the small business debtor category. The election is made on the petition that's filed with the court, and then the case will proceed under Chapter 5 unless the court finds the election was improper, or file an objection by the U.S. trustee or a party in interest. Now, interesting, the last point of this page is there are cases now that say that even after you file a Chapter 11 case, that is not a Subchapter 5 case, obviously, even if it's over a year old and you can't confirm it under 1129 of the Bankruptcy Code, you may still elect to proceed under Subchapter 5. And there's several decisions out there that have allowed that to happen. And so that's good news for everybody. Next page, Jody. Okay, so the important thing on this page is to go down to the last point, which is that, or last 2 points, which was prior to the enactment of the CARES Act, the aggregate debt was about $2.7 million. Based on the CARES Act, they increased the debt limit to $7.5 million, excluding debts to affiliates or insiders for cases filed after March 27, 2020. So there's been a lot of discussion out there that the belief is that there's going to be a substantial number of Subchapter 5 cases now based on the increased debt limit. And I know we're seeing filings here in the Middle District and so forth. Last point on the subchapter 5 is that, last couple of points is that there's no creditors committee appointing these cases unless the court decides to appoint one for cause. And then secondly, there's no fees due to the United States trustee. The case is administered or by a specially appointed subchapter 5 trustee. The debtor in possession remains as debtor in possession, and the subchapter 5 trustee is allowed to intercede in the case and be involved in certain aspects of the case. There's a significant number of slides here. I will also point out to you that Judge Bonifel in Georgia, Northern District of Georgia, has a 100-page guide that he's published that's available, I think, on the ABI website. It's been updated to May 2020. And also there are additional materials available on the ABI website. There's whole seminars presented just on this part of the bankruptcy code. So we're just trying to be very, very brief. Okay, the next topic I'm going to talk about is tax benefits to corporate debtors, and I'm going to move through this pretty quickly so we can get on to the other topics. The big issue here is net operating losses, I believe. So under the CARES Act, net operating losses from 2018, 2019, and 2020 may now be carried back 5 prior tax years. The other big issue on this, 2 big issues would be, number one is that, to go to the third point, if you go back to pre-2018 tax years, you're going to get the benefit of a much more favorable rate than it was adopted under the Tax and Cuts and Jobs Act. So to the extent you can go back and carry this amount back, that's going to be very, very beneficial to Chapter 11 debtors. Also, the income limitations, the 80% taxable income loss limitation has been suspended for years 2020 and earlier. So that's also going to be a great benefit. So what I would say about all these tax benefits, there's a substantial amount of tax benefits in the CARES Act. It would be that, employee tax specialists, I'm not a tax attorney, but would be to understand all these issues and how they're going to relate to your particular debtor. Joe, do you want to go on to the next next topic? Which would be the, yes, thank you. Go to the first slide, please. So I'm going to touch very briefly on foreclosures and evictions, which there are state and federal issues here. The governor of Florida has entered 2 orders. Page 1, please. The governor of Florida has entered 2 orders dealing with foreclosures and evictions. And originally, people were unsure. The first order was dated April 2nd, 2020, and it ran through May 17th of 2020, and it essentially suspended mortgage foreclosure actions and residential eviction causes of action until May 17th. It does not relieve anybody from any obligation to make a mortgage payment or rent payment. Next slide, Jody, please. So the big question that came out of this was, does this really apply to commercial foreclosure cases? Because when you read the actual order, the original order, in the preamble to the order, it talks about residential foreclosure cases, but then when you get down to the part where he actually suspends the foreclosure matters, he doesn't differentiate between commercial and foreclosure. So everybody's taken a look at this, and everybody believes that you can reasonably conclude that the commercial foreclosures are also stayed by the order. At the top of this slide, also recently, May 14th, Governor DeSantis extended this date through June 2nd, 2020. And I'll touch briefly on the federal issues on the next couple of slides. Jody, will you flip this over, please? Okay. Also, the judicial circuits. I know in Hillsborough County, which is our circuit here, in Orange and Osceola County, there are administrative orders out there which specifically suspend commercial mortgage foreclosure actions. So their reading of the governor's original order was that even though it wasn't specific, that did apply to commercial foreclosures. Next slide, please. And then the Supreme Court of Florida has issued an administrative order dated May 4th, which has suspended all risks of possession through May 29, 2020. I have not seen anything yet that indicates whether that's going to be extended, since that's going to come up next week. Next slide, Jody. And then on the federal level, the next 2 slides will be that the FHA has essentially suspended or put a moratorium in on any foreclosure eviction actions with respect to FHA insured mortgages. And this has been extended through June 30, 2020. What's interesting is that this was issued the same day as Governor DeSantis extended the Florida deadline to June 2nd. So the question is, even though these are FHA loans, and on the next slide, you'll see the Freddie Mac and Fannie Mae loans, The question is whether or not the governor is going to go ahead and extend out the state's order to June 30 to make it essentially the same date as the federal matters. Next slide, Jody, please. And this is the Fannie Mae and Freddie Mac, which essentially they're going in tandem with the FHA on the suspension. Okay, last topic, Jody, the unemployment, please. Slide 1. Okay, so I'm not going to spend a lot of time on this. I'm sure everybody sees this on their nightly news, reads about it in the newspaper, online, and so forth. But this has turned out to be a major nightmare in the state of Florida as far as the unemployment situation. And so, you know, as everybody knows, there was a bad system in place. There was a new website put up. The state started taking paper applications. Essentially, in Florida, the duration for unemployment is 12 weeks with a maximum payment of $275 per week. Next slide, Jody. And which is one of the worst ones in the nation. And then you can potentially get more up if the unemployment rate rises to a certain level. Certain requirements listed in these slides were waived by the state as far as things you had to do to comply with the unemployment program. Next slide, Jody. So the big issue here in the CARES Act is that the federal government has added a payment of $600 per week starting March 29, 2020 for a maximum of 4 months, and that ends on July 31, 2020. So the way the program works is that you actually have to go into the state system, computer system, and apply for the state benefits. And even if you're deemed to be ineligible for state benefits, you still can go ahead and get the federal benefits. And of course, there are lots of horror stories about, especially these self-employed employees who are not eligible for state benefits because they don't pay into the program, that they're trying to go in now and get their $600 per week federal benefit through the state system, and they're unable to do that because of the way the system is set up. So, as far as I can tell, it sounds like people are going to go back and be able to get their money eventually, but unfortunately, people are living paycheck to paycheck. People can't make their mortgage payments, they can't pay their rent, they can't buy groceries and so forth because they're unemployed. So the system has been a total failure in the state of Florida. I don't know, how this is going to interact with future bankruptcy filings and so forth. I will tell you, there's a story in the Wall Street Journal today that where Florida was cited as having the worst program in the country to date as far as paying out benefits. The numbers I saw this morning was that there's been $897,000 of benefits paid based on $1.58 million of requested benefits. And this has been going on for quite some time. So this has turned out to be a complete disaster for the state of Florida, an embarrassment. And unfortunately, hopefully they get this fixed at some point, and people will start getting their money. But next slide, Jody. Okay, and I think these are some of the numbers I put out. So that concludes my presentation. I'm happy to answer any questions anybody has. I do want to again repeat for everybody that this information is changing almost daily. The other thing I will mention, and to back up Judge Mora's summary of the litigation right now, is that, and I haven't seen the article yet, but apparently there's an article in the Wall Street Journal today that's basically chastising the SBA for making the PPP program so complicated and so difficult, and sort of making up the rules as you go. And so forth. And I think the idea was that this next tranche of the money, the $310 billion, would be readily available to people, but it's not really happening, and people really still aren't able to get the money. So thank you, everybody. That concludes my presentation. Jody?
Thank you, Charlie. I'll also add, just as a tail on to Charlie's presentation, that there is expected additional federal legislation coming down the pipe that will affect bankruptcy procedures in Florida. It is anticipated that that legislation might include extension of small business exclusivity periods, extension of commercial lease deadlines beyond the current 60-day period, expansion of exemptions to include stimulus funds, and a grant of additional court emergency powers to extend deadlines as appropriate. Okay, we're going to turn now to discussing the court intervention for COVID issues in Florida bankruptcy courts. We have this part of the presentation set up as a panel. So there are going to be several folks, several distinguished commentators who participate in this process from varying angles that are going to comment on what practical solutions are being employed by the courts to solve the issues that have come up since COVID kind of took over. I do have a couple of disclaimers to make first, though, before we start asking questions. And those include that nothing said today during this presentation is binding on the presenter or necessarily reflects his or her personal opinion or position. Please do not attempt to hold a presenter to a comment made or a perspective shared today. This information is presented for the general benefit of issue awareness and to assist attendees in navigating the complex issues that are arising as a result of this COVID-19 pandemic. Also, information and circumstances are evolving rapidly. So to anyone viewing this presentation from the Business Law Section website at a later date, please be aware that there is a good possibility some of this information may have already changed. Stephanie, I need you to allow me to share my screen again because we have additional PowerPoint slides we'll need for this next part of the presentation. But moving forward, the first issue that we want to discuss is with respect to post-petition rent due on non-residential real property under Section 365D3. How has COVID affected a Chapter 11 debtor's ability to meet those obligations, and what solutions have you seen to combat that issue? Judge Mora, have you seen that in your court?
Thank you, Jody. There have been a couple of Chapter 11 cases where it's come into court and been somewhat cash poor. They have asked for leniency in keeping possession of their premises, notwithstanding their inability to pay rent during the first 6 days of the case. In one of the situations I had where the debtor actually had failed to pay rent for 3.5 months prior to the commencement of their bankruptcy case, but were otherwise getting funding from a parent entity, I refused to put the first 60 days of the case on the back of the landlord. And although the debtor claimed it had offset claims that would make the rent not due and payable, I required at least that the money for the first 60 days be escrowed and be made available in the debtor's attorney's trust account, so that if the debtor was capable of getting a plan confirmed, there would be no question but that the landlord would get paid. And if the debtor was unable to prove set-off claims, then it would have those funds available. Now, what was critical was when that first 60-day period was over, the debtor came in and did two things. One, they said, Judge, we want to dismiss our case because we want to go get funding under the PPP program. That was the first thing they said. And then they also responded to a motion to enforce by the landlord because, lo and behold, the debtor hadn't paid their rent for the month of April. And as a result, I ended up requiring the debtor to use part of that money that had been escrowed for the first 60 days of the case to pay the April rent, directed that it be used for that purpose, just to keep the case going. Ultimately, the parties all went to mediation on the issue of dismissal before Judge Hyman as a judicial settlement officer, and the debtor did end up dismissing its case, but with lots of protections built in for the landlord and other creditors in the case. So that's what I have seen so far. The question really is whether the bankruptcy courts have the authority to relax certain deadlines, like extending the 60-day period for a Chapter 11 debtor not to be performing under its lease. And at some point, you really have to balance the interest of the debtor versus the interest of the landlord, and whether or not the case is going to be carried on the back of the landlord. At the same time, though, you want to be sure that you recognize that if the debtor ends up not paying rent, number one, based on what Charlie has just advised us, state courts aren't issuing writs of possession to evict the debtor from the premises, and so they're likely to be able to stay in for some period of time. And in addition, we want to just be sure that the landlord is cognizant that if the debtor is unable to pay rent at this time, it may be very difficult to get a replacement tenant to come in and occupy that premise as well. So we've really been trying to encourage landlords and Chapter 11 debtors to play well in the sandbox and hopefully not require us to have to make a legal determination as to whether we have the authority to extend that 60-day period under 365. But let me turn it over to Guy, who may have other experience in other districts.
Am I unmuted? Okay.
You'd be muted.
Someone muted me again. I have canvassed my attorneys in both Miami and Tampa on this issue, and we've seen it pretty much the way the judge has dealt with in her court. We've seen motions for relief from the stay where the issue is brought up. We've also seen affirmative motions by debtors asking for the extension of time to pay. In most instances, I've seen the judges have been very sympathetic to the debtors, but also understanding to the problems that the landlords are facing. It's a domino effect. So the debtors can indicate that they haven't been making money during the COVID situation, but the landlords are also struck with having to pay debt service or things of that sort on their own premises. So for the most part, I've seen the judges punting the issue, asking the parties to, they've adjourned the motions out, see if they can work it out. And I know, just as the judge indicated, where she noticed and told the landlords, look, you don't have a replacement tenant likely coming in this environment, but you're still getting some landlords using that as an argument for the court to give them the relief that they're looking for. So that's where we are right now. Obviously, if the debtor was deficient prior to the filing, it's not going to change by COVID or by PPP loans, things of that sort. So I think, without giving you kudos, Judge, I think you've been handling it quite well, and I think that's probably the way it probably should go at this point.
No surprise that corporate debtors may have seen an interruption of cash flow as a result of shutdown and other COVID interruptions. Has that also led to issues needing adequate protection or cash collateral obligations?
I have not experienced in any of my cases any situation where there has been real battles at this point over creditors' claims for adequate protection. I think at this point, as Guy has noted, the lenders sort of realize that they need to be working with the debtors at this point. I mean, I have one debtor now that was in the process of selling its business in order to fund its plan. And frankly, the buyer's financing was put on hold pending getting through the next couple of months of the pandemic. And everyone is just sort of extending out the dates for the sale to close and for an amended plan and disclosure statement, providing for all of that to be filed, because folks just recognize there's really no place for the debtors or the lenders to go at this point. We're all sort of just stuck in the status quo. And that scenario is being repeated in a number of cases, Jody.
What about abatement under 305? Is that a good solution for any of the complications that we're seeing right now on substantive issues?
That's an interesting question. So under Section 305, what the parties are actually doing is essentially asking the judge to abstain. And Judge Bluebond, who sits in Los Angeles in the Central District of California, received that request from one of her debtors. The debtors asked for the court to abstain from their Chapter 11 case under Section 305A. And after hearing argument, Judge Bluebond granted that request by the debtors so that the debtors could go and apply for PPP funding. She entered an order saying court hereby abstains pursuant to Section 305A, and the case is deemed closed on the docket. And she said during the abstention period, for all purposes, the case shall be treated as if it were dismissed. But it wasn't really dismissed. She was just abstaining. And what was interesting was she provided expressly a protection for the post-abstention company that I think raises one of the questions that was raised earlier, which is that during the abstention period, the debtors, the post-abstention company's creditors, are prohibited, enjoined, and precluded from any enforcement action against the anticipated PPP loan proceeds, and we're not going to be permitted to levy on those loan proceeds in an attempt to collect their pre-petition debts. And then Judge Bluebond set a subsequent hearing in this dismissed case for July 22nd to reconsider whether the case should be reopened. So at least one judge has thought that this was a viable solution to facilitate this Chapter 11 debtor getting PPP funding. Jody, I think you need to unmute.
Thank you. Sorry. Mr. Niwe, what sort of accommodations have become necessary to combat issues that are arising in Chapter 13 cases?
Well, the two big things that the CARE Act provided that beyond the things that Charlie mentioned earlier with the PPP funding and the stimulus payments are the creation of a mortgage forbearance agreements and an amendment to Section 1329, the modification of confirmed plans. With the mortgage forbearance agreements, this is something that a borrower of a federally backed mortgage loan on a residence who experiences a financial hardship as a result of the COVID emergency, regardless of their delinquency status, can request a forbearance, basically just submitting a written request. Actually, it doesn't even have to be a written request because of the situation we find ourselves in. So it's a request, and then affirming that they are experiencing some sort of financial hardship as a result of the COVID emergency. So what that then does is that triggers the mortgage lender to say, okay, we are under the CARES Act, we can offer you up to 6 months, 180 days forbearance. After that 180-day period, if that financial hardship that is COVID related still exists, you can ask for it to be renewed for another 6 months. What's interesting about that there's no documentation that's required to be submitted to the lender. All it is the debtor affirming that they are experiencing a financial hardship. What we've done in the Middle District is the big question was, well, can the debtor and the lender kind of have these communications without violating the automatic stay? So Chief Judge Delano entered an administrative order essentially saying that any sort of discussions regarding forbearance agreements are not considered a violation of the automatic stay. However, if the debtor is represented by counsel, the lender should communicate with the debtor's counsel unless they are authorized to speak directly to the debtor. So there's still some sort of semblance of kind of protection of the debtor in this situation. As I delved into this and prepared for this seminar, one of the things I realized is there are terms of art in the lender world that I was unaware of. And in fact, our administrative order kind of mixes up some of those terms of art. A forbearance agreement is not the same as a deferral agreement. A forbearance agreement is a suspension of payments. And essentially what you have to do at the end of that forbearance period, you have to begin the regular payments again and then repay the suspended payments within a certain time, either by adding on to the regular payment or a lump sum. It all depends on that forbearance agreement. So anybody out there who's considering a forbearance agreement should probably find out what's the requirement at the end of this forbearance period. Do I have to pay it in lump sum? Do I have to pay it in 3 months? I think that there's argument that if you're in a Chapter 13 bankruptcy, you can spread the post-petition arrears out over the remainder of the plan term. A deferral, on the other hand, is deferring payments for a specific amount of time and then having those repaid at a specific date. And usually that's, we're going to tack it on to the end of the loan. But that's really akin to a loan modification, which does require production of documentation and the financial hardship. So there's a difference. And so it's important to make sure that when you are talking about a forbearance, you're talking about suspending payments, and a deferment arrangement is really when you are deferring them to a date down the line. So as far as these forbearance agreements, one of the questions is how do you deal with them when somebody gets them? And I mean, currently I've got in the last month about 25 to 30 forbearance agreements that I've been notified. The lender has filed a notice of forbearance agreement. And how are they going to be dealt with? It's easy if it's a pre-confirmation Chapter 13 plan. The debtor can just amend and skip those payments and address how they're going to do the ongoing Chapter 13 plan payment, whether it'll reduce or not. But if it's a confirmed plan, it's going to require some sort of a modification to change that disbursement and maybe even impact the plan payment. And so different courts and different divisions, I think, are dealing with it differently. I can tell you that in the Jacksonville division, I really considered this to be kind of an emergency, and I thought we were going to have a lot more than the 25 that I've seen. So our judges agreed to a form that I file, which is called a notice of intent. It's very long-winded. A notice of intent not to make further monthly mortgage disbursements and temporarily reduce the plan payment. And really all it is just a notice saying we're going to drop the plan payment by the amount of the mortgage, and we're going to stop making mortgage payments because a forbearance agreement has been entered into and it's on record. And then at the end of that forbearance period, the debtor is going to have to modify to figure out how they're going to pay back these suspended payments. But at least we were able to do that quickly when, in April, when we were getting these, requests to stop, don't send out my April payment, we were able to kind of effectuate that quickly. Other districts and other divisions are saying, sorry, you need to modify, you need to provide us proof of this financial hardship because we're not going to reduce the plan payment unless you can show that. So we have different ways to deal with the forbearance agreement. Another modification issue that the CARES Act impacted is the amendment to Section 1329, which essentially is saying that if the debtor is experiencing some sort of COVID-related emergency and has a material financial hardship, they can modify the plan, and after notice and hearing, it can be approved to lower their payments. And that plan can be extended to up to 84 months, which has now gone from a 5-year plan to a 7-year plan. The provisions of Section 1322A and B and Section 1323C and 1325A confirmation requirements all still apply when you're dealing with this particular tack on to Section 1329. The question, and I've got about 50 pending right now of the 7-year plan proposals, and they have not gone, well, some have gone to hearing, but they were pretty much agreed to. But we've got a number set up for hearing. And the question that we're trying to resolve is, I think it's clear that the debtor is going to need to show that there is a material financial hardship that's COVID related. And that should be pretty simple and pretty easy. The question then becomes, if they prove that, is it an automatic jump into a 7-year plan, or do you consider the provisions of Section 1325A3 that says you have to propose a plan in good faith? And if there's really not a need to extend it to 7 years, is that a good faith proposal of a plan? So stay tuned for that. There are a number of hearings coming up in the next month, which should decide that issue. And I guess, we'll know then. But those are the two big things that the CARES Act provided for in Chapter 13 that we're seeing a lot of. And that's where we stand as far as not a lot of decisions just yet, but just a lot of activity.
Thank you. Social distancing and stay-at-home orders have caused complications in almost all public spaces, and bankruptcy courts are no exception. All 3 districts in Florida have entered administrative orders dealing with courthouse closures to the public, remote operations, deadline extensions, and accommodations for acquiring clients' wet signatures. But other procedural issues are not so easily solved by the entry of general administrative orders. The UST's office has been at the forefront of many of these issues. Mr. Van Balen, how have the procedures for 341 meetings?
Thank you, Jody. We obviously made a radical change, this having come on suddenly, and basically everything came to a standstill. We had to initially suspend all 341s, and then we had to come up as quickly as possible with a process which would allow us to do 341s remotely. That meant coming up with a process with getting telephonic conference lines for every single Chapter 7 and 13 trustee throughout the country, getting them recorders mailed to their offices or their homes, figuring out how to do the recording process, and then figuring out a process by which we would work with the clerk's office in scheduling those 341s. I give out a shout out to all the clerk's offices, certainly in Region 21, that assisted us with regard to this process. But so basically now when your 341 notice goes out with the notice of commencement, it has a date and time, which is telephonic, and a telephone number and a password that all parties can participate. It's been a bit of a challenge, but it has worked fairly seamlessly in connection with getting debtors to appear. Most of them are doing it from the comfort of their own home. Some are taking advantage of going to other locations with their attorney and such. But at this point, it's all telephonic. We're not doing anything on a video side with regard to that. Some of the issues that we initially addressed and were concerned about were debtor ID. Obviously, both the courts and the U.S. trustee program are always very concerned about fraudulent filings or any other kind of issues similar to that. So we put into place some provisions that allowed the trustees discretion on providing debtor ID. Some of them will require proof of identity to be emailed to the trustees in advance of the meetings. Some will require affidavits by the debtor, sometimes by the attorney, sometimes as verbal verification by the attorney of the debtor's ID. And so that has worked. Nothing is perfect, but in this crazy world right now, the pandemic, we're doing the best we can do. Additionally, we have extended the 341 remote going out right now. All cases that are filed through July 10th of this year will be held telephonically, which will get us certainly well into August. And I'm not certain what's going to happen after that point. We haven't gotten further guidance in connection with the 341s.
Thank you very much. What about the subchapter 5 small business election that became an option just before the pandemic became a problem, Mr. Van Balen? Have Florida courts seen a steady stream of elections thus far? How are those required status conferences being conducted, and how long do you think those procedures will have to stand?
Well, obviously that was another thing that we spent a lot of time early this year getting revved up for. Initially, it was slow in terms of the case filings. More recently, filings on the subchapter 5 area have increased fairly dramatically. It seems to flip-flop between my two offices. More recently, it's been Miami area that has more that have been filing, and then a few weeks before that, it was Tampa. Ironically, I think Tampa is still ahead in terms of the cases filed in Florida at this point. In fact, Region 21, which is basically covers Florida, Georgia, and Puerto Rico, have probably the most sub-chapter 5 cases filed in the country up to this point. I think that there's been still a slower process in the revving up of sub 5 cases because of the PPP loans. I think that has stalled the potential filings of various small businesses. I think we will see more of that once that money runs out. So I would expect that to percolate quite a bit. We are prepared. We have appointed Subchapter 5 trustees in all the divisions, and they're well-qualified financial people or attorneys with financial background. I think you asked also about the remote procedures will mirror those that we are having with regular 341s. Obviously, the courts will dictate what's going to happen in terms of appearances for court or for status conferences. I know in the Middle District, it's now through the end of June at least. The same thing with the 341s, IDI conference, things of that sort will all be held remotely for the foreseeable future. Thanks.
Thank you. And finally, what about Rule 2004 exams, other discovery issues, evidentiary hearings? How is social distancing affecting how those procedures take place right now? Judge Mora, maybe we can start with you and then see if the others have comments.
Yes, thank you. Jody, if we could go to the last slide in the administrative orders. So let me just talk about how the Southern District has responded to the COVID situation. First of all, and I think this is common throughout the districts, I think we need to be on a different group of slides, Jody. All of the non-evidentiary hearings that are taking place right now are occurring by telephone throughout the districts. There are two different services that are being used, either Court Call or Court Solutions. Very slowly, most of the judges in the Southern District have been migrating over to Court Solutions. I think there's still just one or two who have elected to stay with Court Call. That has been done as well in the Middle District and the Northern District. The issue is, what about evidentiary hearings? A number of us in the Southern District have been also conducting evidentiary hearings by Zoom video conference. As you can tell with us learning how to even share a screen on this webinar, it's a skill set that needs to be learned over time. But when the federal courts looked at the issue of could we proceed in compliance with the federal rules in conducting a remote hearing, the important thing was that we wanted to make sure that at all times we could see the witness, we could see the lawyers, and if there was an exhibit that needed to be put up on the screen by one of the parties, we could see the exhibit but still maintain our ability to view the witness's face, demeanor, and the like, so that we could perform our judicial function of determining the veracity of the testimony that's being offered in a hearing. And so we made a lot of tweaks to Zoom, and we in the Southern District feel pretty comfortable now about conducting evidentiary hearings via Zoom video conference. At this point, with the consent of the parties, if there's a particular party that's uncomfortable with it, we won't set it, but people are getting more and more comfortable with it. In addition, in the Middle District, Judge Vaughn, I understand, is going to be conducting evidentiary hearings by video conference, and Judge Jackson at this point is doing evidentiary hearings, but only by phone. The other thing that is going to be a change, at least in the Southern District, is we are adopting the Middle District model of having exhibits for evidentiary hearings being uploaded via CMECF. The Middle District has done that for a number of years, and when this whole thing happened, we were still sort of in the Stone Age of requiring flash drives to be delivered to the court. Well, with the courthouses themselves shut down to the public, that really wasn't a viable solution anymore. And so a number of judges were permitting exhibits first to be emailed to the chamber's inbox, but we needed a more permanent solution than that. So we adopted the Middle District module for CMECF, and literally any day this week, or maybe next week, but hopefully this week, there will be a new administrative order entered in the Southern District of Florida that will direct all exhibits for evidentiary hearings to be filed via CMECF. The exception, of course, is for pro se parties who don't have access to CMECF, and there are special provisions in the new administrative order allowing them to email those exhibits to the clerk of the court, who will then upload those exhibits onto CMECF so they'll be available for all parties. In addition, the rule will provide that the attorneys who are involved in the evidentiary matter must make appropriate arrangements to provide those pro se parties with access to the exhibits, either by email, by a cloud sharing process, or if all else fails, by sending them by express means. The issue of how long this is all going to last is obviously of concern to a lot of people. The courts are really trying to evaluate what is necessary until there is a vaccine to ensure that lawyers and other parties in the case can adopt to the social distancing requirements that are so important to avoid the spread of the disease. And so we in the Southern District have been following the guidance of the doctors and the scientists who tell us that it's very important to ensure that, particularly if you're in a room with no windows and a sealed environment, that there is air purification going on. Well, in many of our courthouses, we don't have those kinds of systems in place. And so, at least for the time being in the Southern District, Chapter 13 calendars, at least through September, will continue to happen via whatever telephonic service that particular judge has set up. For example, in my courtroom, we use Court Solutions, and my Chapter 13 trustee is conducting Chapter 13 calendar, the consent calendar, via Court Solutions. And then when things are brought before the court, either confirmation hearings or motions, then I will join the Court Solutions call and we'll deal with those things via Court Solutions on a telephone conference call. The question is with evidentiary hearings. I know that we're using Zoom, but I do think that it's easier for the parties to be in a courtroom to conduct an evidentiary hearing, and we recognize that. But because of this concern about the sealed environment that each courtroom is, we've been provided guidance essentially that people coming in would have to maintain social distancing. Everybody would have to be at least 6 feet apart from one another. If you're not addressing the court, you need to be wearing a mask to limit, the emission of any potential virus particles to anyone else that's in the courtroom. Obviously, if the witness is testifying, we sort of need the mask off their face so that we can truly observe their demeanor and make the appropriate judicial determination of the witness's veracity. So that's really important. And because that's happening, the guidance to us is that we may need to clear the courtroom every 45 minutes and employ some kind of air purification machinery to run through the courtroom for about 15 minutes or so, and then we can let everyone back in. We're also looking at the issue of, well, if lawyers are addressing us at the podium, do they have to wear a mask? Can they take the mask off? Is it going to interfere with the audio capability, particularly with the digital audio recording system that we use? And if they're going to take their masks off, do we need to have little microphone covers? So the court is looking at a bunch of different issues to ensure the safety of the participants in the bankruptcy system. We're very mindful that we owe responsibility to the public. At the same time, we also know that it's very important to keep the courts running. So Jody, if I could, I'd like to go back a few slides, and I want to talk about some of the administrative orders, the one that's called deadlines and waiting signatures, that the courts have employed in order to make sure that the system will still work. And so you see listed on this slide a number of administrative orders that have been entered in each district in Florida to ensure that we have a viable system. Now, the Bankruptcy Code and the Federal Rules of Bankruptcy Procedure set a number of deadlines that are, according to the existing text of the code and the rules, based on the initial 341 meeting date that is set by the clerk of the court when the notice of filing goes out to creditors. Each of the districts have entered an administrative order that extends out those deadlines based upon the extended 341 meeting date, the actual date that either the bankruptcy trustee or the trial attorney at the U.S. Trustee's Office conducts the first 341 meeting, rather than the initial date that was set, and that was due to the initial dates all having been continued for a number of weeks until, as Guy explained, the telephonic appearances system was put into place. In addition, there's a whole issue that has been discussed in a number of cases that have been decided recently throughout Florida, dealing with wet ink signatures. Virtually all the courts have required debtors' counsel to have wet ink signatures. What do we mean by that? We mean an original signature written on the documents that had to be verified, the petition, the schedules, the statement of financial affairs, and any other verification that had to be filed by a debtor in connection with their initial filings. Each of the districts have entered administrative orders not requiring wet ink signatures anymore, and in lieu of that, authorizing debtors' counsel to accept either a scanned PDF of a signature from a debtor or a facsimile, or even accepting signatures. I know the rule in the Southern District provides for this via signature software like Adobe Sign or other similar kinds of signature software that provides for signature authentication. The issue, and finally, providing a means for pro se debtors to be able to file bankruptcy as well. In the Southern District, we have set up an email box for pro se filers to be able to email to the clerk of the court their request to commence a bankruptcy case and these other documents that need to be filed in a verified fashion, and requiring those parties who are doing that to then bundle up the original documents with their original signatures and snail mail them, send them by U.S. mail to the clerk of the court along with a copy of their picture ID and other ways to verify that indeed this is a filing by an individual debtor. In the Middle District, they are accepting paper filings. The Northern District is also not requiring wet ink signatures. So the critical thing on this is the courts are trying to be responsive to the needs of the bankruptcy community. And in each district, you really need to go to your particular court's website and look at the administrative orders that have been entered in response to really the very difficult circumstances that we are each trying to get through in order to get back to normal. Hopefully this isn't our new normal, but hopefully these administrative orders are going to facilitate practitioners as well as the judges and debtors to be able to move forward and create some sense of normalcy with respect to the practice of bankruptcy law in the coming months.
Thank you, Judge Mora. Mr. Niwe, Mr. Van Balen, did you have anything to add to that? We are over time, but I wanted to give you a chance to make a comment if you had one.
Go ahead, Doug.
The only thing I would say is that in a Chapter 12 case, we had an emergency evidentiary hearing before Judge Jackson by Zoom, and that may have convinced her to do things telephonically.
And I would just add that we have done, or some of our attorneys have done 2004 exams through either Zoom or other vehicles. It's a little bit more challenging, as Judge Moore indicated, about getting the documents and before the parties and doing that. But with the right preparation, it works. Obviously, from the DOJ has not approved the use of Zoom by us in initiating calls. We can, like today, we can participate. So I guess at this time, many of the parties are using the court reporter's abilities to set up the calls and then have the 2004 exams as well. And they are working in this environment.
Jody, I'm going to mention one more thing, and that is that I was actually just alerted by Judge Kimball that he is thinking very seriously about moving his motion calendar from Court Solutions, which he's using now, to Zoom video conference for every motion calendar as well. So he's an early adopter. I'm not sure I'm ready to go quite that far at this point. The thought of trying to manage, 30 or 40 people on a Zoom call is a little bit beyond my technological abilities, but we'll see how it works. We'll make Judge Kimball our guinea pig.
And Jody, I see that there's one other question that, regarding my 341 discussion. The question was whether or not virtual 341s will become the norm. At this point, I have no guidance. I know it's much more convenient to parties. They can do it from the convenience of their office or their home and not have to take time off from work and things of that sort. But at this point, the department has not given us any guidance on whether or not that will become the new norm.
Okay, thank you very much. And thank you to all of you for participating today and for sharing the information and insights you have with all of us. I think it's been very helpful. I also want to say a thank you to Tracy and Stephanie with the bar who helped us get all of our technological stuff set up and troubleshoot issues while we were rolling today. So thank you to both of them for their efforts. The PowerPoints that you've seen today during the presentation are going to be uploaded to the Business Law Section website. So those will be available as resources for those of you who maybe had to jot furiously as we were going through slides and trying to cover material quickly. You will be able to see those PowerPoints and have that information available to you. Thank you very much for tuning in. We're sorry for going over, but we hope that you got some good information out of this that's going to help you going forward in your practice. So thank you very much. And I think that will end the presentation.
Thank you.